case set for a permanency hearing following a final order. And we have several people here who will participate. I'm going to ask for announcements. We'll start with Ms. Kyler Green.
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Kelly Fetters, permanency specialist for Belong.
Jennifer Harris, attorney and guardian ad litem for Jelena and Jesus.
Do you want to state your name, Ms. Pettis Vega, or are you primarily just observing?
I just observe, Your Honor.
And I did read the report, and oddly enough, I remember this case because I was the judge when it started, sadly. So I know there's 2 children left in the case, although I guess the oldest child is 18. So I don't know if you want to ask questions, Ms. Kyler Green, or how it would be the most efficient way to proceed.
I can, Your Honor. I can ask some questions.
Okay, thank you.
Thank you. Ms. Fetters, good morning. Where's Jesus placed right now?
So Jesus is in trial independent living, and he is located in the Houston area.
And since our last court hearing in the spring, has he graduated high school?
He has.
And he transitioned from the facility that he was living in into this independent living?
Yes, he is on his own with a roommate in an apartment.
Does he have a job?
So during the transition, we did a face-to-face transition, and his educational binder with all of his documents was not given. It was then mailed, certified, and it was lost in the mail. So his independent living specialist is assisting him in getting all of his new documents. But he is registered for a program that is on the job, hands-on, where he will get paid, but he will also be getting college credit hours. And that's actually starting this month. From my understanding, they have already gone and requested a new a new state ID, birth certificate, and social security card.
Okay, good. The last hearing, the court had also asked if all of the PALs and circle of support and all of those aspects to get him towards independent living had been completed. Have all of those been complete?
Yes, all of those are completed.
Okay. Additionally, the court ordered for Belong to assist in attempting the children to have access to their siblings. Has that been able to be effectuated?
So the children that have been adopted, that is not something we are able to do. Both of the older youth, though, do have each other's information. They are both in new placements with new freedoms, and they are enjoying their new freedoms. And Jesus currently has a girlfriend he is very involved with, and he spends all of his downtime. I have spoken with him, and I've spoken with Jelena as well. Do they want to visit? Do they want to get together? And they said they would let me know. They have each other's cell phone numbers. I've given them both their aunt's number if they would like to reach out to her, who lives in San Antonio. But they've kind of made a new friend group. And again, they both are in placements with new freedoms they've never had. So they're just enjoying those freedoms and going out in their areas with their friends.
Okay, so let's talk about Jelena. What sort of a placement is she in?
So she is actually at LifeWorks shelter. I had put in for a TLP placement for her to start preparing her for independent living. And she was sent to LifeWorks shelter to eventually head to their TLP program there. Unfortunately, their TLP program does not accept CPS youth. They only accept youth out of foster care system. So she has been there 90 days. She is excelling there. So I requested another 90-day extension to keep her there. That way she can attend school, where she's already been registered. She started there. She's only attended a week before summer started. And she's doing great at that shelter. I don't want to see her go back to an RTC or a GRO because she has earned the new freedoms that she has. She basically, the hours are from 6 a.m. to 10 p.m. She just has to be back by 10 p.m. every evening. She just needs to kind of let them know, hey, I'm leaving. She doesn't even have to give them an exact location where she's going, and she just has to be back at 10. She's excelled in that environment.
And do you think it's in her best interest to stay there?
I do.
And do you think that there will be any problem getting that extension granted for her to stay there?
So I have already gotten then another 90-day extension for her.
Okay. Are there any things pending that she needs to for her independence in terms of birth certificates or driver's licenses or ID cards, anything like that?
So she is currently enrolled in taking driver's ed, and then they will assist her in getting her driver's license. She's completed all of her PALs. She's had her circle of support. She has all of her legal documents. We're just waiting for the driver's license. I did get some gift cards for her. She previously identified and used the pronouns he, him. She has since changed to she, her, and needed some new clothes. I was able to secure her some gift cards. She wanted to be able to go and pick out her own clothes. And those gift cards are already in the mail. So she has all of her needs being met at the shelter. She's doing wonderful. There's no incidents. She's really understanding consequences, that if she does make a decision to do something, she understands the consequences. There have been no outbursts, she gets along with everyone. Wonderful. Her case manager spoke about her with such compassion that she's just a great kid. She's got a great head on her shoulders. She knows what she wants in the future. And that, I mean, she's excelling in the environment. Even though it is a shelter, it's really not. She has turned her room into this paradise in such a short amount of time. It was like a couple of days. She turned these blank walls into this beautiful environment and made it her own. So she is excelling at her placement.
Okay, that's wonderful. Thank you so much, Jonah. I have no further questions.
Ms. Harris, do you have any questions for Ms. Fetters?
Yes, ma'am. What is the plan after the 90-day extension for her?
So we are currently, I am in the process of updating her Common App again, just because, it's been a few months. Hopefully we will be able to find her a TLP. She is wanting to stay in the Austin area. She is on the waiting list for SAFE Alliance. Belong is not contracted currently with them, but I have reached out to the contracts department to get us for them to start the contracting process, because she is wanting to stay in the Austin area. She was denied originally by the 4 TLPs in San Antonio, but she would really like to stay in the Austin area.
No further questions, Judge.
I have a question. Do you think that her experience and record at being so successful where she is now should help her be able to get into a TLC? I mean, it seems like she's a perfect candidate for what they're looking for, as someone who actually can be independent and learn skills and, is capable of being independent.
Yes. So I am rewording a lot of her items on her Common App. It's about a 20-page form that I am working on rewording the things where she has, learned the skills that she hadn't had previously. So, and then what we will do is we will send them back out to the TLPs as well.
Because I know a lot of kids want to go to TLCs and they're really not capable of being successful because they just don't have the judgment or maturity to be able to do the things they need to do. And it sounds like she's, a perfect candidate for that. So I'm glad you're working on that. Ms. Harris, do you have any reports or things to add to this situation?
No, Judge, I'm sorry. I'm at a courthouse, so there's a little background noise. They're both doing great. They're great kids. I wish we had more opportunities for them, but I appreciate the opportunities that we do have.
Okay. I mean, it sounds like they're doing great, and I'm so glad to hear that. And I hope we can support Jelena to be able to kind of be rewarded for her good behavior and her good judgment and choices and things like that. So I'll be keeping my fingers crossed that you'll find something good for her after the next 90 days. So, but it sounds like you're on top of it, Ms. Vetter. So that's good. Anything else to add from the department that we that we need to include?
I don't believe so, Your Honor. I don't think there's anything that we're requesting of the court at this time.
Okay. And as far as Jesus is concerned, are you just wanting to have extended jurisdiction, or is it trial independence? I'm not quite sure what the order will reflect in terms of, because I think he's already 18.
Ms. Fetters, do you want to answer that?
Yes. So we will continue to have him underneath, I would say, our jurisdiction, because we do pay for his living expenses.
Okay. That's what I was thinking, because it's not really independent yet. So,
right. It's independent living, but with the assistance of the
state. As far as the legal terminology, to me, our choices are trial independence or extended jurisdiction, and it sounds like extended jurisdiction is more appropriate. So, all right. So at this time, the court will find that placement of both children is in their best interest, and that those placements are meeting their needs. As to Jesus, the court will order extended jurisdiction to the department to continue to be able to monitor and support Jesus's living situation since he's now 18. Obviously, and I don't know if they've already been filed a dismissal of conservatorship, but the court would grant a dismissal of conservatorship and an order of extended jurisdiction as to Jesus. As to Jelena, the court will continue her placement and again, find that it's in her best interest, and will continue the all current orders as to Jelena, and we'll trust that Belong will be able to find a next step for her that will be appropriate. It doesn't sound like there's any additional orders needed, since it sounds like the court was concerned at the last hearing about some of the documentation, which sounds like that's being remedied at this point. Is there anything else specifically that needs to be ordered as far as you know, Ms. Kyler Green? Yeah, Kyler Green?
No, Your Honor. Thank you.
Okay. All right. And let's see. I can't remember when our next hearing is. January 4th, 2024 at 10:30 will be our next permanency hearing following a final order. I'm really, so many of these cases that are older and the kids have aged out of care or don't have very good outcomes. So I'm encouraged that this one seems like we may end up with a positive outcome for both of these kids. So that's encouraging. So keep up the good work, Ms. Fetter, and we'll hope for the best. Texas being heard today, August. All right, there's nothing further. Then you all it was originally set as a dual setting permanency hearing / final. My understanding is it's just going to be a permanency hearing today. So we're going to proceed under the permanency hearing. As I want to hear announcements from everybody, but I previously mentioned before I call the case that the court had appointed Richard Saldivar as attorney for unknown father. Mr. Saldivar filed a notice of his attempts to locate or identify the father, and he has been dismissed from this case by the court since he's fulfilled his duties that he was appointed to carry out. So let's have announcements from the others that are left on the case, starting with Ms. Kyler Green.
Good morning, Your Honor. Emily Kyler Green, attorney for the department.
Kelly Fetters, permanency specialist for Belong.
Deborah Fuller standing in for Rochelle Acevedo, who represents the mother, Vanessa Ruiz. And as you stated, Your Honor, she was going to announce not ready for the trial, but ready for the permanency.
Okay, thank you.
Kathleen Savage, attorney and guardian ad litem for the child, Your Honor. I'm ready.
Okay. All right. So and Ms. Zarowski, would you identify yourself for the record, please, ma'am? And unmute yourself if you're on mute.
Yes, ma'am. Mary Zarowski, foster mother of Michael.
All right, Ms. Kyler Green, I'll let you proceed.
Thank you, Your Honor. Ms. Fetters, let's begin with the mother in this case. Have you been in contact with her?
So when she was released from prison, she did call me that same day. We talked. I let her know where we were at with the case. She did request a visit with her son. I told her that the visits had been stopped due to her lack of compliance and her not willing to drug test.
When was the date of her release from confinement?
She was released. I will have to look real quick. June 20th is the day she called me.
Okay. And was she able to exercise any visitation at that point?
No, visitation had been terminated for her due to her not having any visitation and her unwillingness to drug test.
And that was court ordered that the visitations had stopped?
Correct.
Okay. What were the services that she was ordered to engage in?
She was ordered to take a parenting class, find a stable and safe residence, look for employment and be employed permanently, an OCR exam, drug testing, therapy, and anger management classes.
Okay, so let's start. Oh, is that all?
To start with, yes.
Okay, so was she able to complete parenting?
No, she was not.
Was she able, to your knowledge, to find stable and stable housing?
No. The address that she gave us in Uvalde is a dilapidated home with no utilities.
Okay. Have you visited that residence?
Yes,
that
monthly.
address?
Yes, monthly.
Okay. Was she able to have employment?
No.
Did she complete an OSAR?
No.
And when was the last time she drug tested?
She has never drug tested for the legal case.
Okay. Was she able to engage in any therapy?
No, she engaged in none.
And what about the anger management class?
No.
What was the last time that she visited Michael?
She had one visit with Michael on February 24th. During that visit, she did fall asleep on 2 different occasions. And on this second occasion, the visit was stopped. She was 30 minutes late for the pickup time. So instead of getting her 2-hour visit, it only ended up being about an hour and 15 to 20 minutes. We did stop the visit 20 minutes early due to her falling asleep again.
Would you consider her to be in compliance or not in compliance?
No, she's not in compliance.
Okay. And in terms of the unknown father, have there been any other names given or attempts made to figure out who the father is in this case?
So I was court ordered to speak with the maternal grandfather. I did speak with him. He states he doesn't know. No one in his family would know who the father is. Ms. Reese does not know who the father is. She was unable to give us any names.
Okay. Okay, let's talk about Michael. How is he doing?
He's doing very well.
Where's his placement?
His placement is in Florenceville.
And what county is that?
Wilson.
I don't know.
Is it Floresville? Is in Wilson County?
Yes, Wilson.
Thank you, Your Honor. Is this a foster to adopt?
Yes, it is.
Okay. What's the permanency goal for Michael?
It would be an adoption by an unknown relative.
Okay. What procedures, if any, has begun to assist in this permanency goal in terms of adoption?
So the foster family that Michael is currently placed at has expressed an interest in adopting Michael.
Okay. And is Belong helping them begin that process?
That process wouldn't begin until the parental rights have been terminated.
Sure. I just mean making sure that all the ducks are in a row, I guess,
yes.
preemptively.
Yes. So his foster parents are 100% on board with getting Michael all of his medical needs that he has. He has extensive medical needs. And she can give you more detail on those because they are extensive. He has 3 rare genetic disorders. He has cerebral palsy, obstructive sleep apnea. He's legally blind. He is losing hearing. And that is a side effect or a outcome to one of the genetic disorders that he has.
Okay. Is he up to date on all of his medical, dental, and vision?
Yes, he is.
even though it's extensive medical appointments, but he's still up to date.
Oh, yes. She has a list. She sends them to me ahead of time and gets me all the notes on time. He has appointments probably every other week.
Okay. Is this placement meeting his needs?
Yes, he is.
Is he on any other sorts of medications that need to be re-upped?
He is on one medication. I cannot remember the exact name, but it is to reduce the spasmodic movements from the cerebral palsy. And then he is on Nexium for the reflux.
And are there any, or have there been any attempts made for any family members to care for this child?
Yes, so we did do a kinship home study for a fictive kin family. Basically, they pulled out once they knew of the extensive medical needs for Michael. They were not able to handle the extensive medical needs that Michael has. He has 4 different therapies that he gets multiple times a week. Obviously, he would be unable to attend to daycare, and they just didn't feel like they were well suited to handle Michael. Any family members were not able to care for him due to a broken safety plan with a previous sibling of Michael's.
Are there any attempts to have contact with his siblings?
So the foster mother has reached out. In the very beginning, we did reach out to see if they would like to be placement for Michael. The people that adopted the other sibling, and they did not feel they could meet Michael's needs.
What's the department requesting at this time?
That his placement be continued, and that we try to get the trial scheduled as soon as possible to get this baby permanency, just because of the unknown risk of these 3 very rare genetic disorders.
Okay. Thank you, Your Honor. No further questions.
Ms. Fuller?
Ms. Fetters, in your report that was filed on July 11th, you did not list anger management for the mother. Is that a task that she has to do or not?
It was to go over originally within her therapist. I was not the original caseworker on the
question was, is that a task or not? Because even in individual counseling, it doesn't mention anger management.
Okay, we can remove that as a task.
Well, I just need to know if it's a task. Ms. Acevedo wanted me to make sure I wrote down everything that her client needs to do. Is it or isn't it?
It will be a new task on her new family plan. Yes, it will.
Okay. And so was there domestic violence in the past? Is that why it's being added?
Correct.
Okay. And then you didn't mention the psychological. That's still part of her task, right?
That is correct.
Okay. And all the 2054s or the necessary paperwork, I don't know what they call it, through Belong, are those all still in effect?
Yeah, so she has been referred to places in San Antonio. She requested myself to refer her to Uvalde because that's where she resides. When I spoke with her again,
Ms. Fetters, my question is just, are the 2054s in place?
So the 2054s are not in place. The referral.
Okay, that's all I need to know. I'm looking at your report also in regards to the child. A lot of the appointments have already taken place, but there's no update. So for the appointments with the PCP and the cardiologist, those appointments occurred before you wrote your report. So are there any updates from the cardiologist and the ophthalmologist, the neurologist, all those that were listed in your report, but no updates given?
Yeah, so I do have the updates. We get the updates.
Okay. And so is there any new information since it wasn't included in your report?
No.
Okay. And so what efforts will you continue to do to try to have Ms. Ruiz engaged in services?
Just continue to try to locate her.
And then when is the last time you saw her?
I have never seen her.
So even when she had the visit, you didn't see her?
No, ma'am, this was not my case.
And do you feel that you've made all reasonable efforts to try to locate the father?
Yes.
And it's your testimony today that this foster home is an adoptive placement, and that's the intended permanent home for this child.
Yes.
Thank you. I'll pass the witness.
Ms. Savage?
Yes, you were saying the 2054s are not in place. What was the reason for that?
So they have expired. Once they set up the appointments, that's when we send them back out.
Okay, so
the referrals are sent out. A 2054 is a payment voucher. So we don't send out the payment vouchers until the parent actually schedules their appointments, because we've already sent up these payment vouchers on 2 different occasions. So basically what I have emailed the providers is, once she schedules the appointment, let me know and I will send out another payment voucher.
okay, so the mother never made that extra step to schedule this appointment.
That's correct. She won't answer the phone to schedule the appointments.
Okay. What other efforts have you tried to locate the mother?
So I did locate her when she was in the Bexar County Jail, and I was scheduled to visit with her. Unfortunately, she was released due to overcrowding. I spoke with her. She stated she was going to be residing at the residence in Uvalde. The very next day, I went to the residence in Uvalde, and she is not there.
Okay.
And currently her phone is disconnected.
Was there an address in San Antonio that she was residing at?
She would not give me any address in San Antonio. She stays with different people. She doesn't have a permanent address.
Okay. So that's another barrier to reunification, is mom's instability.
That is correct.
Michael's doing well in his placement?
Yes, he is.
And you believe that placement to be in his best interest?
Yes.
I'll pass the witness, Your Honor.
Any other witnesses, Ms. Collard Green?
No, Your Honor. Thank you.
Any thing you would like to report at this point, Ms. Savage?
Your Honor, Michael is doing really well in his foster home. He does have many medical needs, but she's doing a great job making sure all of those are taken care of. He is completely off the oxygen right now, but they're still addressing a lot of the other issues, the reflux, the blindness, the hearing. So he still has a long way to go, but I do advocate for continuation of this placement. And I would ask that the reason why we didn't proceed with merits today was because Ms. Acevedo was going to be out. So I would ask that we set merits sooner rather than later. We have an MIA parent who hasn't done anything and isn't visiting with the child. And even when she had visits with the child, wasn't making those a priority. So I would ask that we set that hearing very soon.
Okay, thank you. Anything you want to add, Ms. Fuller, on behalf of your client or Ms. Acevedo?
I just wanted to, just so I have my notes correct for her, the medication for the child, because the report says that he's not on any medication. So I wrote down Nexium and one other medication, but I don't have the name of that one.
And that may be something that the foster mother
maybe
could answer.
Yes, Your Honor, I can answer that if I'm allowed to.
All right, thank you, Ms. Roski. Go ahead and answer that question, please.
Yes, ma'am. The drug is called baclofen, and it's basically similar to like a muscle relaxant that helps with the spasticity and the tightness that comes from the cerebral palsy.
Okay.
Thank you, ma'am, and I appreciate all you're doing for this young child.
And
Yeah,
I do too. It sounds like a huge job, and I really do appreciate what you're doing. We need people like you, and we don't have enough like you. So is there anything else you would like to add that you think would be important for the court or other parties to know about Michael?
I mean, no, his attorney and Ms. Fetters know a lot about him. He's an amazing little boy who's just overcome so much and is the happiest little baby on the face of the earth that we love dearly. So
that's wonderful. I'm so glad. Thank you for all you do, and keep doing it. Is there anything anyone else would like to add before the court makes findings?
No, Your Honor, I just asked that the plan of service be given, attempted to be given to Ms. Ruiz again, since there's items on there that are being added.
Okay. All right. Then at this time, the court will find that the mother is not in compliance with the plan of service at this time. She's, it sounds like, done absolutely nothing throughout the course of this case, except for a couple of not successful visitations early on in the case. And I will find that Belong has made, and the department have made reasonable efforts to locate her, as well as to locate any father in this case. I think the department has also made reasonable efforts to attempt to return the child to a parent, but that's just has not been possible. I will note that the court did, at the last hearing, suspend visitation until the mother engaged in services. So we'll continue that ruling of no visitation until the mother comes forward. I guess I would order Belong to try to make one more attempt to provide the mother with the updated plan of service, just to cover all bases before this case is set for trial. It sounds like it's going to be pretty difficult to locate her, but I appreciate just the continued efforts that you're making to try to maintain contact or initiate contact with her. I will continue the child in his current placement and find that placement is in his best interest. I would be very, opposed to any attempt to try to move him to another placement. And I'm wondering, because Ms. Fetters said that the permanency plan is adoption by a relative, but it seems to me that plan should be changed to say adoption by the current placement. I appreciate the fact that the department has tried to locate a relative, but that has not been successful. And it seems like at this late stage of the case that it's really not in his best interest to continue to try to move him. But I'm not sure what the department's position on that is. Do you know, Ms. Keller-Green, if that's a legitimate permanency plan?
Well, Your Honor, I'd actually like to ask Ms. Fetters again if that was what she said. I thought I heard her say, well, maybe I thought I heard her say kinship adoption, but or adoption by non-relative.
She said unknown. She said unknown relative, and I think she meant non-relative. I think that's what she meant.
Okay,
is that what you meant, Ms. Fetters?
Yes, it is.
Okay, so the department Belong is not actively seeking another person at this point. Obviously, if someone came forward and identified themselves as a relative that was interested, I'm sure you would do what you need to do to try to assess that situation, but you're not actively seeking to move this child to another placement. Is that correct?
That is correct.
Okay.
And Your Honor, I will say though that all reasonable efforts to locate a family who could take this child have been met.
Okay, and the court will find that the department and Belong have made all reasonable efforts to locate relatives for placement, and that those have not been successful. And I will note that this child has multiple needs that are above and beyond what a quote unquote normal child would need. And I can only assume that those needs will continue to be great and maybe even greater as he gets older. And so I think that that just makes it more difficult, because as Ms. Fetters testified, there's a relative who was interested, but honestly evaluates that they're not able to meet those needs. And I appreciate people who can be objective enough to say that they're not able to meet the needs of the child instead of just trying to see what they can do. So I do find that those reasonable efforts have been met as well. I will order this case to mediation. I will note that currently the case is set for trial on November 2nd at 10:30. Obviously, if you all can mediate, or if you can decide on an earlier date, that's something you would have to check with Ms. Greenlee and Judge Falkenberg, who would be the ones hearing the final trial. And I'm ordering the case to mediation. I will say though that if we can't get mother to show up, there's really no point in doing it. But if we can, if Ms. Acevedo can reach her and she can have her attend a mediation, that would be optimal. But I don't intend for you all to just get together and show up and her not be there and waste everybody's time. So
I know there's a criminal attorney, Your Honor, that Ms. Acevedo had been speaking with,
okay,
but she hasn't had any luck locating her.
Okay. Okay. I mean, it makes it very, very difficult, obviously, to do anything that's consensual or by agreement on this case when you just don't have one of the most important parties that is not engaging. So I feel like y'all are doing the best you can to try to facilitate that. So for now, we'll just leave the final trial at November 2nd at 10:30. That will give everyone notice today that that's the date of the trial. And if that needs to change, it's something y'all will have to discuss with Ms. Greenlee about Judge Falkenberg's schedule. All right. Anything else then?
No, Your Honor.
And again, thank you, Ms. Zarowski, and thank you to Ms. Fetters also for, making attempts to try to see what we can do with this parent. So, all right. Anything else? 2023 views. All right. Then, if nothing further, then you're all recorded. We're set today for a final trial. I've been told that the department has a motion on file that we may want to entertain first. So let's go ahead and have announcements, and we'll start with Ms. Kyler Green.
Good morning, Your Honor. Emily Kyler Green, attorney for the department.
Okay, thank you. Ms. Ibarra, would you state your name, please?
Sierra Ibarra, forensic specialist with caseworker for this case.
Okay.
Jennifer Harris, attorney for the respondent mother. She is not present, Your Honor. She is in court on a case related to this one, but I am ready.
Okay, thank you, Ms. Harris. Mr. Saldivar.
Oh, sorry. Richard Saldivar for Aaron Davila, the father. He's not present, Judge. I haven't had contact, so I'm not ready.
Okay.
Judge, give me 1 second. Lisa Greenwald just texted me about the court reporter. I don't think she has the correct login because she's not in the waiting room.
Okay, I just remember that Lisa told me there would be a court reporter here today since we're sent for trial. So we'll hold on just 1 second.
And, Your Honor, did you want me to announce?
Yeah, go ahead and announce, Ms. Dye.
Yes, Sherry Dye on behalf of Elaine DeLeon, the maternal grandmother who is the intervener, and we are present and ready.
Okay. And Ms. DeLeon, would you state your name, please?
Elaine DeLeon, Your Honor.
Okay, thank you. And let's see, who do we need? Ms. Savage?
Kathleen Savage, attorney and guardian ad litem for the children, Your Honor. I'm ready.
I think I kind of cut out on me, Ms. Roden, but we have Ms. Roden with CASA also. All right, let's wait a second for the court reporter. Since it was set for final trial, the court did arrange to have a certified court reporter present. As I said, this proceeding is being recorded via audio and video recording, but we also had arranged for a certified court reporter. And is that the Uvalde DA's office?
Yes, ma'am.
Okay, thank you. All right, so now that everybody's on, I will just kind of state that this case is set today for a final trial, but it's my understanding that the department has also filed a motion for an extension, that we'll entertain that motion first, but we appear to have all parties present. So I'm going to start by asking, and I will clarify that we are now being recorded by a certified court reporter as well as our audio visual recording. So Ms. Kyler Green, you may go ahead and start.
Thank you, Your Honor. The department filed a motion for an extension for extraordinary circumstances. The parties had previously mediated this case and had come to an agreement. However, since the date of mediation, there has been a protective order issued by the DA's office that prevents Ms. Davila from being around her children. And so because this recently happened and it very much so changes what the agreement was and what the visitation plan was and where the case was heading towards, the department has filed this extension to allow time for the dust to settle and for us to figure out what our permanency goal is going to be for these children and what is the best way forward.
Okay, that seems like a pretty extraordinary circumstance, and I think it's that's a pretty significant roadblock. It may be that case is being heard as we speak. I don't know, because maybe Ms. Harris can fill us in, but let me just hear what the position is of the other parties in terms of granting an extension as of today. Because I will note that I did read the report, and it sounds like the permanency goal has been family reunification with a concurrent goal of relative adoption. So that would put a big hurdle up against family reunification if that protective order is to stand. So, Ms. Harris, what's your position about the extension today? Oh, and by the way, I will overrule Mr. Saldivar's not ready announcement. So go ahead, Ms. Harris.
I will note that the status report was not filed until very late. So I haven't had a lot of time to go over it, but because we're in support of the extension, we need to go ahead with a permanency hearing today. So we are in support of the extension.
Okay.
And we're
all right, Mr. Saldivar, do you have any objection to the extension?
No objection here.
Okay. And then what about Ms. Dye?
Your Honor, we don't object to the extension. There are just some other things I think we would like to address to be in place while that is pending.
And that's we can certainly address that and go forward with a permanency hearing, or at least a status hearing of some kind. Ms. Savage, do you have any objection to the extension?
No objection to the extension, Your Honor.
Okay. All right. So I don't know whether, to me, it doesn't seem like there's a necessity to have extensive testimony regarding the extension, and that there's enough for the court to grant the extension because this is a pretty extraordinary circumstance. And then we can, this is my suggestion, and I'll entertain other ideas. If I can go ahead and grant the extension, then we can go ahead and address some of the permanency issues today. And we only have 30 minutes allotted for it. I have a little extra time this morning, but not much more than that. So does anybody object to me going ahead and making a finding as to the extension?
No, Your Honor.
Objection.
No objection.
Okay. All right. Then the court will find that extraordinary circumstances exist that warrant an extension in this case. As was stated by Ms. Kyler Green, the extraordinary circumstances include the fact that the DA's office has recently filed a protective order against the mother, preventing her from contact with the children, which completely disrupts the previous plan as family reunification with the mother. So that it sounds like it's being addressed at this very moment, or at least very contemporaneously to today's date, that issue will be, we'll know more about that. And once we do, then there may need to be some readjustment of how to proceed forward in this case. So do you want to put on testimony, Ms. Kyler Green, in terms of permanency, or do we want to just throw it open to?
I can put on testimony, Your Honor. We can have a permanency hearing.
Okay, go ahead.
Okay, I'll call Miss Ibarra.
Okay, she's been sworn.
Okay, Miss Ibarra, where are the children currently placed?
Children are currently placed in a foster home in Goliad, Texas.
Okay, can you, Your Honor, if it's okay with you, could I ask her to turn her camera off so her bandwidth might be better?
Yes.
I think she's having connectivity issues.
Yeah, we have a little bit of a delay in your feed, so if you would just turn your camera off. Yeah, that's great.
Thank you. Okay, foster placement with Goliad. Has this foster placement put on notice?
Yes, we put a notice on July 6th and ends on August 6th. So the children need to have a new placement by August.
Okay, Your Honor, did you get that?
Yes, the foster home put in notice, and we'll need a new placement for children by August 6th, I think.
Okay, and do you know the reason why they put in the children on notice, or their placement on notice?
The foster agency put a notice in due to
objection, Your Honor. Objection, Your Honor. Calls for hearsay.
Well, Your Honor, I'm not asking for it for the truth of the matter, but
I'll allow her to go ahead. This is a permanency hearing. We need to know what's going on with the placement. So go ahead and answer that question, Ms. Ibarra.
The foster agency put a discharge notice in due to Ms. Davila on the fall 3 times in the month of June.
I'm sorry, Missy Barr, you're cutting out, and we didn't catch that last sentence due to the mother something.
Can I try to call in and see if that works better?
Yeah, that's probably going to be better. Yeah, that's better. Okay, go ahead and answer the question about why the children are needing to be moved.
Yes, the foster agency put a discharge notice for the children on July 6th due to Miss Davila or Miss Cannon calling CPS on the foster placement 3 times in the month of June.
Okay.
Okay, and so those calls, were they investigated?
Yes, they were investigated.
Okay, and are the children after those calls? Did the children remain in that placement?
Yes, they remained in the placement.
And do you know why, despite the fact that the children remained in the placement after those 3 calls to CPS, why notice was actually given to have the children removed?
I believe it was due to the foster agency not wanting to continue to work with Miss Cannon, as well as the foster placement's mental health. She was, getting depressed, and she didn't want to risk losing her license, so she can continue fostering. So it was best that the children were moved from the placement.
And how long have the children been in that placement?
They've been at that placement since August of 2022, so almost a year.
And I mean, I guess currently, since the children are still there, has that placement been meeting the children's needs?
Yes, placement has been meeting the children's needs.
And was it in their best interest to remain there?
For the time period of the discharge notice, yes. We do have possible placements for the children.
I'm sorry. I was about to interrupt you, and I didn't hear your answer. You do have a possible other placement for the children?
Yes.
Okay. Is it a priority to keep the children together?
Yes, it is.
Okay. Are the children's medical, dental, and vision appointments up to date?
Yes, they are.
Are they pending any sort of special medical needs?
No, they're not.
Are any of the children taking psychotropic medications?
Yes, all 3 of them are taking medication.
And are those medications up to date?
Yes, they are.
And do the children have any therapies or counselings that they attend?
Yes, they attend individual counseling.
And all 3 children are going?
Yes, all 3 children are going to individual counseling. Family therapy was scheduled for Sophia and Miss Cannon, or Mrs. Cannon, which has been stopped due to the no contact order.
What was the last time that they exercised a visit?
The last visit that they had was it was the weekend before 4th of July, so July 1st.
At this time, would it be safe or recommended for the children to be returned to the mother?
No, not at this time.
Okay, so let's talk about Mrs. Cannon's services. What services was she ordered to complete?
She was ordered to complete a parenting class, a psychological, fit, individual therapy, and parent-child visits. And we did a random drug testing at the beginning of the case. It was a hair follicle. Those results were negative. So due to the results being negative, drug testing wasn't court-ordered. And that is it.
Was there supposed to be the family therapy with Sophia?
Yes, sorry. And the family therapy with Sophia.
Okay. So was Miss Cannon, did Mrs. Cannon complete parenting?
Parenting is an ongoing class throughout the entirety of the case. There's no a completion date. She just has to continue engaging with the parenting program with SJRC.
And has she been?
Yes, she has.
Okay. And what about the psychological? Did she complete that?
Yes, she completed the psychological last year in December.
And what about BIP?
She was expelled from BIP classes in April due to missing 3 classes. She has to restart. The referral has been sent out, and she has been notified that she needs to restart BIP classes.
Okay. What about the individual therapy?
Yes, she does engage in individual therapy with Dr. Yates.
And how is that going?
It was going good. Dr. Yates has given positive feedback and saying that she's doing good, and she's actively engaging in therapy.
Okay. And what about the parent-child visits? Were those appropriate at the time that they were engaged in?
The visits were appropriate. The children's behavior after the visits was not appropriate.
Can you elaborate on that?
Yes, after the visits, when the children were returned to foster placement, they would start acting out and not listening to foster mom, kind of, reverting back to their old behaviors when they first got to foster placement. There was a lot more fighting, a lot more outbursts.
Okay. And what is your understanding right now as to the no contact order that's been issued by the DA's office?
That Mrs. Cannon is not allowed to have any contact with the children at all. That's my understanding.
Are you aware of an expiration date to that no contact order?
No, I do not. I've been not informed of any expiration date.
Okay. Has the permanency goal changed since this no contact order?
We haven't discussed a change to the permanency goal yet. I think we're waiting for the criminal case and to see what the outcome was with her criminal case. If there's a no contact order still in place, I believe the permanency goals will change to adoption by relative.
At a certain point in this case, there was, I think, supervision of the children and Mrs. Cannon by her husband. Is that correct?
Yes, that's correct.
Okay. And so how were those supervised visits at the time that they were allowed?
They were appropriate.
Okay. Okay. Your Honor, I have no further questions. Thank you.
Ms. Harris, any questions?
Yes, Judge. Ma'am, you mentioned that there was family therapy between Sophia and her mother. How was that going?
It was going good.
Have you talked to that therapist about what effect it might have on Sophia to stop that therapy and stop seeing her mother so suddenly?
No, I have not talked to him about the effects it would have on Sophia should the visit stop suddenly.
Do you think that might be important to get some feedback from her therapist about that?
Yes, ma'am.
And for the boys as well?
Yes, ma'am. That's right. That's correct.
And she's doing her parenting, her hands-on parenting with Rebecca Johnson, correct?
Yes, that's correct.
And has Miss Johnson provided you with any recommendations?
No, she has not.
Has she given you any feedback about how it's going?
No, she has not.
Have you asked for it?
Yes, I have.
Okay. Did you not get her letter dated July 7th of 23?
No, I did not get the letter.
And how many times have you asked her for feedback?
I want to say it was about 3 times.
So do you need the court to order for her to provide that feedback to you?
Yes, ma'am.
And what about Dr. Yates? What is Dr. Yates recommending?
Dr. Yates hasn't made any recommendations.
Have you talked to her?
Yes, I have.
Okay. How does she say therapy's going?
She thinks it's going good. She believes she's turned herself around. She has just needs to maintain her sobriety and her sanity, and she's attended every session.
And did Ms. Cannon talk? Go ahead.
She's doing well overall.
And did Ms. Cannon talk to you about why she missed that last BIP class that caused her to be expelled?
I believe it had to do with her being in the car with Philip and that she couldn't be around someone else. She had to be alone for that.
And has the referral been sent out for her to begin that again?
Yes, it has.
When was that sent out?
The beginning of July.
Okay. And do you know if it's been started?
I don't know if Ms. Cannon has started it. I did talk with Optimal Counseling, and they did say they were going to reach out to her. I know that when I had told her that she needed to restart her BIP classes, that she didn't want to do it and that she wanted to find a different class.
She was very near completing her BIP course, wasn't she?
Yes, ma'am, she was.
So she had done 13 out of 16, is that correct?
I believe it was 15 out of 18.
Okay. So do you think it's appropriate for her to do a 16-week course all over again? Or do you think that it could be addressed in another manner?
I believe it could be addressed in another manner.
And were it not for the no contact order, would the Belong be recommending visits at this time?
Yes, ma'am.
No further questions, Judge.
Mr. Saldivar, any questions?
Yes. Have you made any contact with Mr. Aaron Davila?
No, I have not.
Okay. When's the last time the departments speak with Mr. Davila?
June 3rd, the day of mediation. I have not spoken to him since. He has not answered any phone calls or reached out. I did speak with his mother. She did provide a new phone number, and he has not answered that phone. The phone calls to that number either.
Okay. And to your knowledge, does he have a copy of his service plan?
Yes, he does have a copy of the family service plan that was provided to him when he was in jail in Amarillo. I haven't had any contact with him since then, so I have not been able to give him an updated family plan. I did speak with the courtesy worker. I did email the courtesy worker that is assigned to him. I have not received an email back. I just have no luck getting a hold of him. I don't know where he's at. I know his mother states he's in Amarillo, but there's no address.
Okay. Pass the witness, Judge. Thank you.
Ms. Dye, questions?
Yes, thank you. Ma'am, if you know, how many prior cases have the parents been involved in with CPS?
Objection, Your Honor. Not relevant to the permanency hearing today.
Your Honor, it is relevant because of the nature of the classes that we are discussing as far as the mother taking and her involvement in that, and I think it is relevant.
I'll let you briefly discuss that. We do need to kind of move on and see where we're going from here.
Yes,
but
Your Honor.
I'll let you ask a couple of questions. We're already at 11 o'clock, so let's.
Yes. Ma'am, if you know, how many times have the parents been asked to do services with the department previously?
Yes, 3 times.
And are some of the same services that were previously requested that we're discussing today?
Yes, ma'am, that's correct.
So when you were asked whether or not another BIP class would be important or, you know, different things that were previously used, do you have concerns that none of the information has been internalized and put to good use that has been, that they have participated in the past?
Yes, ma'am, that's correct.
And based on the fact that there are pending criminal charges, does that make it even more concerning at this time?
Yes, ma'am, that's correct.
And at this point, do you feel it's necessary that all of these services that you are requesting be put in place for this mother again at this time?
Yes, ma'am, that's correct.
Okay. At this time, what is the department recommending with respect to the children?
Oh, I mean, we want to keep them all together. We're not opposed to placing the children with the grandmother. If we were to place them in foster care, they would be split up at the time, and we do not want to split these children up.
Has my client been...
Let me just ask you to clarify, when you say the grandmother, are you speaking about Ms. DeLeon, the intervener?
Yes, ma'am, that's correct.
Okay, I just wanted to clarify that.
I'm not aware of any motion for that at this time.
I know, I'm just trying to clarify, but and we don't have a motion for that, but let's go ahead and address that, because obviously the children need to be moved.
And may I proceed, Your Honor?
Yes, go ahead, Ms.
Thank you. Ma'am, do you believe that there's an emergency circumstance that would merit placement of those children with Ms. DeLeon?
Yes, ma'am, that's correct.
Has the department been able to vet her home and do a study on her?
Yes, we have.
And are there any concerns that exist?
The only concerns would be if Ms. DeLeon and Ms. Cannon have any contact.
Okay. And has my client been extremely cooperative with the department?
Yes, ma'am, that's correct.
Are you aware of whether or not the children are bonded with her?
Yes, I'm aware that they do have a bond, as well as their older sisters that are placed with the grandmother.
And they were placed there through another case involving the mother, correct?
Yes, that's correct.
And does the department have any reason to suspect that they would not be well cared for in the care of Ms. DeLeon?
I'm sorry, can you repeat the question?
Yeah, does the department have any reason to suspect that they would not be well cared for in the care of Ms. DeLeon?
No, we don't.
Okay. And was the home extremely appropriate?
Yes, it was.
Does it have room for the children?
Yes, ma'am, it does.
And is there especially an emergent need for placement based on the fact that school is starting very soon as well?
Yes, ma'am, that's correct.
Okay. And if you're aware, do you know whether or not the children's attorney was also able to see the home?
Yes, she was.
And was CASA also able to see the home?
Yes, she was.
Okay. And so at this time, would the department support placing with Ms. DeLeon?
Yes, we're not opposed to it.
I'll pass the witness.
Ms. Savage?
Yes, Ms. Ibarra, going back to Ms. DeLeon's services, she was seeing Chandra Esparza up until April or May when she fired her as a therapist. Is that correct?
Yes, that's correct.
So she's just recently started with Dr. Yates, correct?
Yes, that's correct.
And Your Honor, I'm sorry, may I clarify when Ms. Savage is speaking of Ms. DeLeon that she's not speaking of my client?
Oh, I will refer to her as Miss Cannon because she's married now. So,
okay, thank you.
Miss Cannon fired Dr. Esparza, and that was after Dr. Esparza didn't give the best recommendations.
Yes, that's correct.
And this is the therapist she had been seeing for, well, since the case started. Is that correct?
Yes, that's correct.
Okay, so she basically cherry picked to have a therapist who would give her recommendations she wanted, correct?
Yes, that's correct.
And then in regards to BIP, this case started based on allegations of severe physical abuse of the children by Miss Cannon. Is that correct?
Yes, that's correct.
Okay. And so her re-engaging in a BIP class would be very helpful to address the issues for why CPS became involved. Is that correct?
Yes, ma'am, that's correct.
In the recent months, have there been signs that Miss Cannon's mental health has been spiraling?
Yes, ma'am, that's correct.
Objection, Your Honor. She's not a professional to be able to testify to mental health issues. If she wants to generally testify, is what she's seen as a caseworker, but she's not an expert.
She's not being asked to give a diagnosis. So go ahead, Ms. Savage.
Yes. Ms. Ibarra, what actions or signs have you seen about some erratic behavior evidenced by Mrs. Cannon?
Yes, she's been calling CPS and filing complaints, as well as with the children. They have expressed that Miss Cannon does get a little angry and they do get scared and kind of revert back to how they were at the beginning of the case.
Okay. So I want to take those two things that you said one at a time. So in regards to the children, when you've met with them, they've been excited to go with mom, but have they expressed any kind of anxiety or fears about her anger or her aggression?
Yes, ma'am, that's correct.
Okay. And then you said some of the erratic behavior was the constant calling to CPS. She's called in, you said 3 times on the foster mom in the last 2 or 3 months. Is that correct?
Yes, that's correct.
Okay. And are you aware that this is kind of a history for her?
Yes, ma'am, that's correct.
Okay. And none of those investigations have actually yielded any kind of abuse or neglect. Is that correct?
Yes, that's correct.
And it's, were you aware that the foster placement has been licensed since 1998 and has had only 4 investigations prior to Miss
Objection, relevance, Judge.
I'll sustain the objection. Let's move on, Ms. Savage.
Okay. At this time, if the court does not place the children with Miss Elaine De Leon, on August 6th, they would be placed in foster care in 2 separate homes. Is that correct?
Yes, that's correct.
Okay. So the department is asking, based on the 30-day notice, that the department be allowed to place the children with Miss Elaine De Leon.
Yes, that's correct.
Okay. And you're asking for that placement to occur today?
Yes, ma'am, that's correct.
Okay. I'll pass the witness, Your Honor.
All right, let's kind of move on. We've gone through a lot of information.
Your Honor, I have some very specific redirect. I can go very quickly.
All right, good. Let's go quickly, Ms. Harris.
Okay. When did Miss Cannon make complaints to you about the foster family, the foster mother?
Yes, she has. And I did talk to the foster placement after she made those concerns to address those concerns and see if they were valid.
Okay, thank you. And did Miss Cannon also show you a video where somebody was at the foster mother's home yelling at Miss Cannon?
Yes, I did get a video. It was very grainy and I could not really hear the audio.
Okay, that's just yes or no. And Dr. Yates has actually seen Miss Cannon since childhood, hasn't she?
Yes, that's correct.
And she's very familiar with my client and with her mother, Elaine, correct?
Yes, that's correct.
And has Miss Cannon expressed to you whether she's in support of the children going to Elaine?
Yes, she's expressed concerns.
Okay, and are some of those concerns abuse that she suffered from her mother?
Yes, that's what she had told me.
And have you talked to Dr. Yates to follow up with that, since that's why she was seeing Dr. Yates when she was young?
No, I have not talked to Dr. Yates about that.
And was an actual home study done, or did you just visit the home?
I did visit the home, and a home study has been sent out.
Sent out, but it has not been completed?
Not at this time, no.
Okay. So you don't think it would be wise to maybe check with Dr. Yates regarding outcries of abuse by Elaine and any prior cases before placing children there?
I don't believe we have the time. I can reach out to Dr. Yates. Due to the time frame, I would like the children to be placed all together.
And Ms. Cannon wants that as well, but she also ultimately wants her children to be safe. Don't you think their safety should be placed above time limits?
Yes, I am located closer to them if they were to be placed with grandmother, and I can do, checks quite frequently.
No further questions, Judge.
Your Honor, two questions following up on that, or if Ms. Dye wants to.
I needed to follow up as well, so either or.
Well, let me just pause it just a minute. And like I said, we're going into the almost 11:30. So I've heard a lot of information. I want to stop for a second and ask Ms. Savage, as the attorney and guardian or ad litem for the children, what her recommendation is today. Because it seems to me that the court can make permanency findings. That's not very complicated, but the placement of the children is obviously a critical issue today. And I think a decision needs to be made. So I'd like to hear from Ms. Savage and from CASA about what their recommendations are as to placement. And then I'll get back, then I'll let you all go further if you need to. Ms. Savage, what's your recommendation?
Yes, Your Honor. I am in agreement with placement of the children with Miss Elaine De Leon. The concerns the mother has brought up are, it's her doing. So the pattern that I've seen with this mother is that she calls unestablished or unsupported CPS intakes on people. She's done that to Miss De Leon through her history, all of which have been rolled out. And she's doing it to the foster mom. This foster mom had 4 intakes prior to these kids coming home, and now she's got 6 within 8 months of having Miss Cannon's children. This is what she does. She doesn't like what's happening, and so she's making complaints. And now she sabotaged this placement where the children were doing wonderfully. They were doing well, but because of her erratic behavior, now this placement wants nothing to do with them. They want to give notice on the children. Now we've got 3 days to place these kids. And we have a relative who's passed all the background checks, or passed all the preliminary checks. So there's no CPS or criminal history of any of the residents in the home. Her other children, the two older girls, are in the home, and I've talked to them, interviewed them, and they both say the home's appropriate. They still feel safe there. They're excited to have their younger siblings placed there. And so the alternative is to place all these three children in foster care separate. Like, no, absolutely not. I know Miss Cannon doesn't like her mother, and she's got issues with her mom that maybe they need to address on their own time. But the reality is it's a safe place. There's no CPS or criminal history that would stop it. And I can't trust anything that Miss Cannon says because she cries wolf all the time, and everything's been proven to not be true. And I do have serious concerns about Miss Cannon's mental health kind of deteriorating. She was doing well in the case, but then we're seeing erratic behavior. It got to the point where child exchanges have to be occurring at a sheriff's department now because of the hostility and aggression. When I met with the kids, yes, they're excited to see their mom, but they all also expressed anxiety about her aggression and about her temper and if she's really changed. And so that gives me pause. I'm concerned that because Dr. Chandra Esparza's notes weren't the best, that she fires her and she goes with Dr. Yates, who Dr. Yates saw her as a child and is going to be sympathetic and, you know, just listen to the woe is me. But is she really going to hold her accountable for why this case started, which was she beat the two younger children? Going back to the grandmother, it was at the grandmother's home with the older kids, and the older kids and the grandmother were the ones who called police to step in and to save these children. So I think they can be protective. The alternative is putting these kids in foster care separate, and that's not in their best interest. And frankly, Miss DeLeon's made this bed. Had she not made these fake calls on CPS to terrorize placement, they could have stayed where they were. But now we've got a 30-day notice because of the actions she's done. This case started because of the actions she's done. So I think it's in the best interest of these kids to go with their grandmother today.
All right. Thank you, Ms. Savage. Ms. Roden, do you have, does CASA have a recommendation?
Yeah, we would also be in line with Ms. Savage in the department in placement of the children with Ms. DeLeon, to not go into, everything and repeat what Ms. Savage has already shared. I was able to go along with her. I've met with them. I've seen the placement. I've spoken with the siblings. There was some hesitancy by the children when I spoke to them last about placement and just some anxieties. So I would like to see that home, if we place there, visited frequently, like weekly, if possible, to check in on the well-being, at least until we have a full home study. Also, if there's anything unfavorable on the full home study, I'd like for everybody to get together immediately so we could discuss it and address any issues or concerns that may come up. CASA doesn't mind being put in some kind of rotation for those weekly visits to the home. We're willing to assist with that or do our fair share, but we would be in favor and think it's in their best interest to be placed there rather than to be separated in foster care.
Okay. And I think I know your position, Ms. Harris. Is there anything you want to add to your recommendation? Or your
no, Your Honor, the only, my client is, she disputes the issues. I think that the department is as much at fault as my client could be at fault, because the Belong has consistently put it off on my client to be contacting the foster mother to make arrangements, to do things for the kids, things like that. Belong has known for a very long time that the two of them did not get along very well, and that my client had concerns for foster mother, just as foster mother did for mine. And they should have stepped in and been taking care of that themselves, as opposed to leaving my client with no other reason. So I would just add that those be allowed to resume if the criminal court does lift the bond condition.
And Your Honor, could we ask for a mediation? We have a new party. We have a lot of new facts. When we made that visitation schedule, I would just like all of us to get together and try to figure out something else if the bond conditions are in fact lifted.
Okay, that's a good suggestion. And very briefly, Ms. Dottie, anything you want to add? I know you want placement with your client.
Yes, Your Honor. And I just want to add, I may be the only attorney that was on the prior case because it was in another county. And so I will agree with Ms. Savage that the history of mom calling in unfounded reports has been present and going on for quite a long time. She does it to jeopardize placements, and she does it so that this placement could not occur, so that there would be some sort of investigation on my client, as well as on the foster home. The mental health concerns have been present for years because I was on the prior case, and it's been going on for years. My client has not been abusive in any way. In fact, has been a loving grandmother raising her other 2 children. And so we would fully support the placement. I do want to express concern that there is a great likelihood that when and if the court does grant that placement, that mom will continue to call in fictitious reports. I think she just did that in June on the older 2 children that reside with my client. And so I don't know what can be done about that, but I'm fairly certain it will continue to happen because that's the course of action that's been occurring for years.
Okay. All right. Thank you, Ms. Dunn. Mr. Saldivar, any position for your client?
I defer to the court, Judge. I don't know what Mr. Davila would want in this situation.
Okay, that's kind of what I figured. So, okay, I'm going to go forward. I've got a lot of findings and rulings to make today, and you all can tell me if I'm leaving something out. I'm going to find in terms of the permanency hearing that the mother is in partial compliance with the plan of service. She's obviously completed and participating in significant services, but there's some important things that still need to be done. I do think that it's important that she continue with the BIP classes, however those can be worked out. I think it's important that she continue with the individual therapy and parenting. I will find that the father is not in compliance with a plan of service. I am going to order that there's no contact between the father and the children until such time as he participates in services. I'm going to order that there's no contact with the mother and the children until such time as the criminal case can be resolved. I do think it's important, as Ms. Harris requested, that if that case is resolved and that protective order is lifted, we need to look at starting those visits back as soon as possible. I am going to authorize, what I'm going to do is call it a temporary placement with the maternal grandmother or Ms. De Leon, and pending the home study. So this will be kind of like a pre-placement. And when the home study is completed, I agree that with whoever asked this, that Belong needs to distribute that home study to all parties so that everyone can see it. And if there are concerns, that maybe those could be addressed as quickly as possible. I do find
Judge,
that
I'm so sorry to interrupt, but I think Judge DeBose is requesting the Zoom link for this. Okay. Can I give that to her for her to get on real quick?
Sure.
Oh, for Miss Mitchell. I'm sorry, for Miss Mitchell.
Okay, sure. I mean, I'm not going to hang around a lot longer, but that's fine if she wants to log in. All right, I'm going to find that it's in the best interest of the children to make the placement at this time. Since we're in an emergency situation, the children need to be placed within 3 days. We don't have adequate time to have a full home study. So since there have been preliminary checks and both by Belong as well as the attorney ad litem and CASA, that the children can be placed there pending the home study, which means that Ms. De Leon, you'll need to make sure you cooperate with completing the home study. I'm not sure what stage they're in, but they'll probably want to be coming out and visiting with you and talking to the kids. Sounds like you've been cooperative with this effort in the past. So I will note that Judge Falkenberg in his notes indicated at the last hearing, and I would reiterate that it's not in the best interest of the children to return to either parent today, and that neither parent has satisfactorily demonstrated that they have addressed the concerns that brought us to the court today, that there's still some significant issues that need to be addressed. And this is obviously a long-term concern, which may take a while to resolve. I am going to also order that there be, until the home study is completed, at least, that there be weekly visitation between either Belong and or CASA and the relative placement. The onus is really going to be on Belong. If CASA can help provide a weekly visit, here and there, then that would be excellent. But the order really pertains to Belong. Also, let's see. Oh, and I want the children to be in therapy. I don't know if they would need to change therapists with the move, but I want them to be in therapy just as quickly as possible. I am sure it's going to be difficult for them to all of a sudden not be able to have contact with their mother. And so I think that it's important that they be able to talk about how they feel about that in a therapeutic setting. I am going to grant the extension. As I said, there is significant changes since the last hearing that I will grant a new extension for the reasons I stated above. both because of the criminal charges pending and the protective order, but all in addition because of the need for an emergency change of placement. Our new dismissal date will be January 30th, 2024. Next permanency hearing will be October 5th at 10:30. Trial will be scheduled for December 7th at 10 o'clock. I am going to order the case to mediation. I think it'd be important to have that mediation prior to the next hearing, if possible. Hopefully we'll have some more information about the status of the criminal matter prior to then. So I would say if you can schedule the mediation as quickly as possible after the resolution, or there may not be a resolution, but whatever the findings are in terms of the criminal case.
And Your Honor, you had stated that visits to start once that bond condition was lifted. We were having pretty liberal visits. Could we have those either ordered supervised until we go to mediation, shorter length of time?
Well, I think that maybe that's something you all can discuss. I think they definitely need to be supervised. And the other thing I was going to order was no contact at all between Ms. DeLeon and the mother. That means Ms. DeLeon, you can't call her. She can't call you. If y'all have a question, a problem about a visit, it all needs to go through Belong. Or maybe CASA or the ad litem could help assist you. But I think obviously the communication between the foster parent and the mother has been problematic in the past. I see Ms. Busby, district attorney, on the call. And I don't know if you all have any information that you want to report about what the status of the criminal case is. Just for your information, I think Ms. Lopez has been on the call the whole time, but the court has ordered a change of placement as of today, or as soon as you all can facilitate that, because of notice given by the foster family. And the court has ordered no visitation between the mother and the children until the criminal matter is resolved. And I don't have any position as far as whether that protective order needs to stay in place or not. I'm a visiting judge today. I have heard a lot of information, but I'm not here to give a position on what I think about that criminal matter. That's something that y'all need to handle in criminal court. But if that is resolved, then I think the visitation can continue. I think the children do want the visitation. However, there's obviously good reasons for the protective order as well. So I want the CPS case to mirror the same restrictions as the DA's and criminal case would have, so that there's not any confusion, especially for the mother that knows, well, this order says I can visit and this order says I can't visit. So we need them to be consistent. Obviously, if that protective order is lifted, then that changes things. And, you know, what I will say too is that Judge Falkenberg is the presiding judge over this case. If something comes up that needs to be dealt with prior to October 5th, which is our next hearing, that's something that you can take up with his office, Ms. Greenlee or Judge Falkenberg.
And again, Your Honor, you just said if that protective order is lifted, those visits are to be supervised until otherwise ordered, or until we agree.
Yes, or until there's an agreement reached. If you all can go to mediation and agree on what would be appropriate and ensure the safety of the children. You said that the visits have been pretty loose. Maybe that's not a good idea for them to be loosely structured, and in light of the fact that placement is broken down now, largely in part of confusion between the mother and the foster parent. So the last thing I want to see is for this placement to be disrupted because of nothing that has to do with the children, but has everything to do with the other adults in the case. So that's why I ordered no contact between the mother and the foster parent, and that visits would be supervised by someone other than the grandmother. I didn't say that specifically, whether that's by the department or CASA or whoever. That's, you all can come up with how you want to structure that. And that's why it might be, helpful if you go to mediation while that criminal case is still pending, so that you have a plan for how to go forward. Do you have anything, Ms. Busby, you want to add at this point?
Good morning, Judge. The state's position is that the defendant have no contact with her children at this time. And we're not in agreement to her having supervised visits. So until we get more information on the defendant, and we see more information, our position is going to stand at this time.
Okay. All right. And just to be clear, I am ordering that there's no contact between the mother and the children until such time, if and when that protective order is lifted. Right now,
just to be clear, Judge, that's the DA's position. The Judge DuBose is considering whether it should be lifted or not.
Right. Okay. Thank you for clarifying that. So the DA's office is going to be requesting, I understood that a protective order was filed, but I guess it has not been ruled upon.
It is in place. It is in place, Your Honor. My client and her attorney have asked for it to be lifted. The DA's office is in opposition to it, and Judge DuBose is considering whether it will be or not.
Okay.
Well, and let me clarify, the bond conditions on her indictment are that she have no contact with the children. Those bond conditions have not been modified, so they are still in effect.
Okay. All right. So just to be clear, that my position is, as far as the CPS court is concerned, is that if there are bond conditions or other requirements of a criminal case, whether it's a bond restriction or a protective order or whatever those restrictions are, those should apply as well in the CPS case. Because of what I previously said, I don't want there to be confusion about one order says one thing and another order says something else. If Judge DuBose modifies the bond conditions or lifts the protective order, then obviously that's something that we will reconsider in the CPS case. Is that clear to everybody? I just want us to be on the same page. I realize that the criminal case has a different judge. There may be different considerations. I know nothing about the criminal case or what stage it's in or anything. So I just want to make sure that we're not giving mixed messages about what she's required to do. And it is important that she follow the bond restrictions issued by the criminal court.
Yes, it's clear to the state, Your Honor.
All right.
Your Honor, the last request for the department in terms of your findings is for the permanency goal to have changed to adoption by relative based on these findings and the time limits on this case.
And Your Honor, I would absolutely oppose that being changed at this point. They filed their report late. The report said that the goal was reunification. If they want to change it, they need to give us proper notice of that so we can be prepared to argue about it.
Okay. Well, I think that the permanency goal, I guess I'm not prepared to change the permanency goal right now. I think it should be initially a primary family reunification and secondarily relative adoption. But I think that could change as soon as we know the results of the criminal case. In other words, if the mother is still allowed to work services and have visits, then we may be looking at something different. So I'm just going to kind of punt on that issue right now and postpone it until we get more information. All right. Anything from anybody else? We've covered a whole lot of material today. We had 30 minutes and we've taken over an hour, but I think these issues are important. And I really appreciate Ms. Busby and Ms. Lopez appearing on behalf of the DA's office, just so that it helps us have some consistency in what's going on.
Thank you, Judge. We appreciate it. Thank you.
Thank you. Anything from anybody else?
No, Judge.
No, Your Honor.
No, Your Honor.
And I'm assuming that Belong will get with Ms. DeLeon, the grandmother, as soon as we get off of this hearing and make arrangements for how that transfer is going to be made. And I do have a question. Would the therapist be different once they're moved? Yes. And Ms. Salinas, is there a therapist that we can have ready to go? Ms. DeLeon is nodding, so I think that maybe there's somebody in that area that can be ready to go, that just as soon as that move is made. I really want these children to have their first therapy session within like 7 days of the placement, okay? Because they're old enough to kind of know what's going on. They're going to be confused. They're going to wonder why, and y'all can blame the court and say that it was court ordered, and that's what happened. It's not because the mom doesn't want to see them, but I think they do need therapeutic assistance with transitioning to that placement.
Yes, ma'am. I'll get that set up immediately.
Okay, thank you. Anything from anybody else? I know this is a difficult case, and I appreciate y'all all trying to work together. I know that everybody's got their own positions and advocacy, and that's good. That's the way it's supposed to be. So until the next time, we'll be back on October 5th at 10:30. Hopefully everybody's clear about what those orders were. And I'm sure Ms. Kyler Green will prepare the order. And I would ask each of you, when she circulates that, please look at it very carefully. If there's confusion about something that's in the order, I will sign it ultimately. And so if there needs to be clarification, then that's something that you all can work out.
I would ask Ms. Green if she should also send it to me. I'd appreciate it.
Okay. Can you give a copy to Ms. Busby?
Yes, Your Honor.
Okay, thank you. All right. Anything else? Good luck to you all, and I hope that transition goes well for you, Ms. DeLeon. Thank you all.
Thank you, Your Honor.
Thank you.
Thank you.